Hi, good afternoon, everyone. This is Rajiv Eskana from immigration.com, the law offices of Rajiv Eskana PC. We hold this community conference call every 2 weeks, and it is subject to the disclaimers you heard when you were logging in. Before I get started, let me make sure you guys can all hear me.
The conference is now in conversation mode.
Can everyone hear me, folks?
Yes.
Okay, excellent. Thank you.
Yes.
Thank you, sir.
The conference is now in presentation mode.
All right, so I'm going to go over first what I consider to be frequently asked questions. I think there are 3-4 of them. And then I'll go over the regular questions. And each time I answer a question, I will invite follow-up questions on that question. New questions will be taken up at the end, time permitting. I'll lock the conference about 30 minutes into the call so that we can answer everyone's questions who's here. Okay, so that's the plan. Now, let's begin with the frequently asked questions. So this question is, I am on H1. My wife is traveling outside the United States on H4 visa. If she's returning and I change employers, is that a problem? And the answer is no. It is not a problem. As long as you are maintaining your H1B status, the fact that you have changed employers, or even if you're in 60 days grace period, she can return on H4 visa. I don't see any problem with that. And if her visa stamp bears the old employer's name, that does not matter. So this is not an issue. What steps should you take? There's nothing to do. This is perfectly legal. Does anyone have a follow-up question on what I just discussed? Press *5 if you have a follow-up, not a new question, a follow-up question. Press *5 on your phone. Okay, there being none, we move along. Next question, frequently asked questions. Question is, now this is a tough one. H1B or green card misrepresentation, legal options and consequences for fighting back against the US. Question is, have you taken cases of H1B or green card fraud or misrepresentation? Yep, for about 30 years, we've been doing nothing but these things. Everything connected with employment and business-based immigration and complicated immigration cases. That's pretty much what we focus on. So have we done cases like this before? Yes, absolutely. We've also helped criminal defense teams in defending cases like this. What are the consequences if caught in a fraud or misrepresentation? Well, the government can choose to prosecute you criminally because remember, most of the papers you file with the USCIS and the State Department of Labor, all agencies are filed under penalty of perjury, which means if you lie, you can go to prison for up to 5 years. Okay. Felonies are particularly serious crimes. So if they want to come after you, the government could do so. And if they just hold you responsible under immigration laws, a misrepresentation or fraud in immigration is usually a permanent bar from entering the United States. So not only do you lose your stay in the United States, you may not be able to come back at all, ever again. Okay. Can we fight back in court to justify our case? Yeah, absolutely. If you did not misrepresent and there was no intention or it was an immaterial misrepresentation, these are the typical defenses against misrepresentation. Number one, I did not lie intentionally. Number two, this was not material. What does that mean? Material means something which is relevant for the decision or further investigation. So for example, if I go for an H1B visa stamping and the visa officer asks me what time it is. The time is 3 o'clock, but I say it's 2:30. Is that a misrepresentation? Sure. But is it a material misrepresentation? Absolutely not. What does this have to do with grant of a visa, right? So those are some of the grounds that you fight with. But if you don't have any of these arguments, then there's no point in fighting. Okay, what I just discussed, anybody has any follow-up question on this? Nothing new. Any follow-up question on what I just discussed? Press *5. Okay. There being no other questions, we'll go on to the next one. Next frequently asked question. I thought there were more. Oh yeah, here it is. Options for extending stay in the US after layoff as an international student pursuing a master's in IT. So if you go to my blog on immigration.com, I have written out how you can apply for a B1, B2. That's one thing. CPT is another. So let's see what you have said. So you can apply for B2. Yes. And look at my blog. There's an entry on that. Second entry right now. So review that. Second is enroll in a community college and obtain an I-20. Yes, you can do that. If more time is required, I could join a university in the spring semester. So all of these are options, curricular, practical, training, etc. Again, if you go to my blog on immigration.com, I think about 10th or 15th entry is about curricular, practical training. So look at that. I wrote that, I think, a couple of years ago. That's still good law. So read up on it and act accordingly. Of course, there's another option. I have reviewed this before, that you could get a quota exempt job. So look into that. There are frequently asked questions on our website discussing quota exempt jobs. So those are typically the things you could do. Press *5 if you have a follow-up question on what I just discussed. On your phone, press *5 if you have a follow-up question. Okay, this is from California. California, go ahead, please.
Hi, so I have a follow-up question that in case of a layoff for F1 student who is on OPT right now and OPT is expiring, and the layoff has a severance period of 2 months. So for 2 months, the student is still on payroll. Can the student apply for STEM OPT, or could that be considered like not a valid reason to apply for STEM OPT?
Well, there is some doubt about whether payment is enough to maintain your OPT F1 status. For H1B,
that given that it is enough.
Okay, if it is enough and you want to apply for a STEM OPT extension, you will need an employer. If you don't have an employer, you cannot apply for STEM OPT extension.
Right. So right now the student has an employer, but the student is already served with a notice of termination.
So that's what I said, right?
They would be laid off in next 2 months.
Hang on. You're not going to be able to get a STEM OPT extension until you're able to file an I-983, right? That's what it's called, the training form. So you need an employer. You can't, if you don't have a job, don't file that. That's not the right thing to do.
Okay, got it.
Yeah. Okay. Good luck. All right. Bye-bye. Let's see. The next one is area code 775. I don't know where that is from. From Nevada. Okay. Nevada, go ahead. I can hear you. Nevada. Area code 775. Unmute yourself. If you're talking, we can't hear you. Okay, I guess we'll skip you. Let's go back to our frequently asked questions if there are any more. Here's another one. Potential visa complications for an H-1B visa holder due to past employment with a blacklisted company and alternatives for obtaining an H-1B stamp. Came to the US in August 2015, completed my master's in 2017, started OPT 2017 July, applied for OPT EAD, joined an employer, AZ Tech Technologies, joined as an intern, was there for like 4 months. He responded for 2 months during training. After a couple of months, employer did not respond at all. I got doubt and found out another job and moved to a different company. Later on, I got my I-140 and H-1B approved. I'm planning to go to India this year. I found out through social media that the company I joined was a blacklisted company. I'm not answering any new questions. If you raised your hand for a new question, please drop it down. Press star 5 on your phone. Please don't raise your hand until I ask for questions. Now, I'm already on the next question, guys. You have to wait. Job moved to a different company. Planning to go to India this year. Recently found out, okay, this company is inky. Most people who joined got rejected when they went for stamping. Will there be a problem? Yeah, I think so. I know this company. I've heard of this company. So could you please advise me? I know people who have been permanently barred from entering the US because they misrepresented that they worked for this company. Can I advise you? Not really. Not really. I can't really tell you how it's going to play out. But whatever I can advise, whatever little I can tell you is this: just be truthful. Don't try to hide whatever has happened. Of course, if there is misrepresentation in your background, they can bar you from entering the United States forever. But there's not much we can do about that, right? So, okay, these were the frequently asked questions. Any follow-up on this? Press star 5. Nothing new, but any follow-up on this question? Area code 425. Let's see, where are you calling from? 425 is from Washington State. Okay. Washington State, go ahead, please.
Yeah, hi, Rajiv. So my question is related to the first question, that is end of H1B 6-year limit and PERM audit delay. I got delayed in joining.
Hold on one second. I haven't started answering those questions. So I was just answering the frequently asked questions. Stand by. I'll get to that. Okay. I'll get to that.
Thank you.
Now I'm going to start answering the questions that are non-frequently asked questions. So let's go over them one by one. Again, I'll invite for follow-ups. So let's see. This one is end of H1B 6 years limit and PERM audit delay. What are my options? So 6 years are getting over in August of this year, including counting all your out of USA days. Your company filed PERM in May 2022. So what is the problem? In May, which is this month, you are entitled to 1 year H1B extension even if there is an audit. There's no problem. You can get an H1B extension for 1 year because your PERM was filed a year ago, right? May 2022. So I don't see what the problem is. I don't know what the issue here is, sir. I am confused. If you are here, press star 5. Was that you? If you are here, press star 5 on your phone. Okay, you are Washington State. Yeah, so you can get a 1 year extension now. What's the problem?
Yeah, earlier I was not aware of that.
Acha. Okay.
The lawyer also.
Yeah. No problem.
Thanks.
There are two sections of AC21. One is called 104, one is called section 106. So this is section 106 that allows you to get 1 year extension. Okay.
Perfect.
Good luck.
Thank you.
You're welcome. That was an easy one. Now any follow-up questions, guys, on this? Press star 5. Okay, area code 352 has a follow-up question. Where is area code 352? Oh, I don't know. That's very odd. Oh, there are two people with hands raised. That's the problem. So 352 is from Florida. And the other one is from Texas. Okay, let's go to Florida first. Florida, go ahead with your follow-up question, please.
Hi. So this is a question that is specific to my case. So is this the right time to ask? Or I can
No,
wait?
this is not for new questions, only follow-up questions. After I'm done answering all
thank
the
you. I can wait.
posted questions, then I'll come to new questions. Okay, so stand by.
Thank you.
You're welcome. Texas, do you have a follow-up question? Texas? Area code 469? Okay, I guess you did not have a follow-up. Okay, so this we took care of. Now let's go to the next regular question. This is NK Gokana. Case remains pending. Status from the USCIS on an I-485 application with a priority date of June 2013. What will be the next step for green card processing? Eligibility and documentation required while changing employers. Okay, my priority date is June 2013. Case is pending. Immigrant visa numbers are not available. Date is not current. Does this status mean decision has been made or not? So if you're asking me, has your case been pre-adjudicated? I do not know. You can call the USCIS customer service, but this message doesn't really tell me much. I got an RFE for birth certificate, provided as much evidence as I can. May I know what will be the next steps from the USCIS standpoint? Well, I think they might have shelved the case. I have no way of knowing for sure. If they have shelved the case, they will not be working on the case until the dates become current again. Sometimes they complete the adjudication on a case even though the dates are not current. That's called pre-adjudication. So I do not know if your case has been pre-adjudicated. I applied for I-485 in the end of September 2022. It's been more than 6 months since I applied. Am I able to change employers? Yes. And the new employer will have to file supplement J. Correct. So if your I-140 is approved and your 485 has been pending 180 days, you can change employers. Okay. Press *5 if you have any follow-up question on what I just discussed. Nothing new. Just follow-ups, please. Area code 775. I think I know this number. Nevada, right? 775. Yeah, Nevada. Okay, Nevada, go ahead. I can hear you.
Sir, similar question. So I changed employer after I got my I-140 from employer 1.
Okay.
With a priority date of 2011 August.
Okay.
So, but I waited like 10 years almost before changing.
Okay.
At 2019, I changed to employer 2.
Okay.
But after I changed to employer 2, my dates became current. But by that time, I could not apply my I-485 because my employer 2 has filed a new PERM, which is still pending with DOL.
Right.
Right. So, but that date was current for more than 12 months,
okay.
I believe, at that time in 2021.
Okay.
Now, employer 1 wants to take me back at this time, and I got laid off last week, sir.
Okay.
So, employer 1 wants to take me back and is willing to do my H-1B with that original I-140.
Okay.
Right. So, sir, when this I-140, when this priority date becomes current,
right,
will employer 1 be able to continue the green card process by directly filing I-485 without filing any new PERM?
The simple answer is yes, but the complicated answer is but. So if you go back to work for the same employer, can they assist you in filing 485? Sure. An I-140 does not get stale. So technically, an I-140 once approved is good forever. The only thing that can be questioned is, if the job is permanent, why did the employer let you go? And that's something you should discuss with your lawyers. That's a very long discussion. And number 2, if you wanted to work with them permanently, why did you leave them? So either one, this could be relevant, and you should discuss with the lawyers who represent you and or your old employer. But other than that, technically, this is no problem at all. You can file 485. Okay.
Okay, sir, I changed employer because of I was getting better opportunities. My employer was not ready to go with the same opportunity.
Like I said, it's a very long discussion. I can't have it here right now.
Right.
But that's what you need to look at. There's nothing illegal about it. You can definitely file a 485. Okay?
Using that I-140.
Absolutely.
Okay.
All right.
And there is no rule like saying that it was current for more than a year.
Yeah,
so that's why I cannot file.
that rule goes against H-1B extension. So if you need H-1B extension beyond 6 years and you did not file your 485 and the dates become current, they can refuse to give you H-1B extension.
Okay.
But they have to accept your 485. And they also have to give you an EAD. Okay.
Okay. Got it. So
Good luck,
thank
sir.
you so much.
Oh, you're welcome. Good luck.
Thank you.
You're very welcome. Okay, let's go on to the next question. We did this. This is a frequently asked question. Managing H-1B layoffs in the US, exploring possibilities such as B1, B2, H4, etc. Got laid off, including the 60-day grace period and the deferred layoff date. I have until June 30th to find my next job. H-1B stamp expires in September. Husband is currently working on F1 Day 1 CPT, has been picked in the latest H-1B. Okay. PERM has been filed for him as well. In the circumstances that I am unable to find my next job before June 30th, what are my options to say in the US? You already know that B1, B2 and H4. Oh, he's not on H4, sorry, he's on F1. You could go on to F2, definitely. Between the two, probably I would do the F2. You can also do B1, B2. Either one is okay. Yeah, you can only file his for his H4 along with his H1. So when he applies for his H1, you can file an H4 along with it. But if you are going to, so he's in June, right? So they'll apply before June. Okay. So you can file a change of status only if the H1B is still pending. Sure. You can apply for it, but would that be enough to give you status because there'll be a gap to October 1st? I think the government will approve it. That's my guess. Okay. And if you feel that you don't want to take that chance that they could say, well, between June and October, you don't have status, so we can't give you, we'll approve the H4, but we won't give you status. You have to go get a visa stamp and come back. In that case, just apply B1, B2. It's not a bad visa to apply for under your circumstances. Let your lawyers look into it. They can even call the USCIS customer service. Find out if USCIS is likely to give you H4 status, even though it begins on October 1st. Okay. So that's what I would recommend. Press *5 if you have a follow-up question. Press *5. Okay. So this one is area code 469, which is from Texas. Okay. Texas, go ahead, please.
Hello, Rajiv. I think you answered most of my questions.
Okay.
The only, I think, pending question I have is the processing times look really long. So I worry if I go through, say, an F2, then an H4, where my husband moves to the H1 visa, or like any path of going down B1, B2, and then switching back to my H1B. I'm worried like the processing time will get in the way for me able to resume work.
I wouldn't worry about it. What you can do is you can also apply for an F2, and when he applies for his H1, you also apply for H4 with the F2 still pending. Okay. Now, worst case scenario, your H4 could be denied because your F2 has not been approved. You can always go get a visa stamp, H4 visa stamp, and come back. You don't need an approval from the USCIS to do that. And you can go to any country. Mexico is giving you appointments in 2 days. So that would be one option. The other one would be to apply for a B1, B2. There's no huge advantage in that over an F2. It's, I think, about the same time frame. So there's no perfect solution, But the imperfection is simply this, that you may have to go for, if you get a job, H-1B visa stamping. And if there is a gap in your status, H-4 visa stamping. Neither one of them is a big deal. I'll be okay with that. Okay.
Okay.
Makes sense?
That's all good. Thank you.
Good luck, ma'am. Okay. Next one. So this one is an interesting question. If we do an EB1A, EB1B, does USCIS give more weightage to a research paper than a review survey paper, or it doesn't matter? So I am not sure I think the research paper might have a little bit more weightage because it represents original research, whereas the review or a survey paper is basically, it's like a curated summary of research already done. So maybe I think the research paper might have more weightage. My best guess, because technically, even review or survey papers are scholarly publications. They are written for scholarly evidence. So it can be argued, and it should be argued, that they are scholarly publications. And I'm not sure USCIS has the finesse to distinguish between these two situations. But certainly I can feel the difference, and I feel that maybe a research paper would weigh more heavily in your favor. Okay? Or at least I can argue more for it. How about if I'm the only author, no second or third author? Yeah, that's good. Nothing wrong with that. Which is better, 4 papers with 200 citations or 10 papers with 200 citations? I don't think I can tell you the difference. It's so difficult to predict the mind of the USCIS. Sorry. *5. If you have a follow-up question on this, press *5. Area code 917. Let's see. It is New York. Okay. New York, I can hear you. Go ahead, please.
Hi, Rajiv. Thank you. So I've got a 2-part question. First is, have you seen an RFC from USCIS when they ask that, who cited my paper? Does that really matter? Like, whether the person who cited your paper is it like a guy from the street, like random guy, or like top from the industry?
Yeah, I think it matters, and I think I would make a point of it if the top people in the industry were noticing and citing you. I would certainly mention that. So if somebody wrote a paper in Nature or Science and they mention your paper, I think it's a big deal.
But when I file premium, does the adjudicator have that much time to go look
They
at
do
the
not.
200 citations?
They do not. They always screw things up. So if you want to point something out, point it in bold letters. Don't think they are going to be able to figure it out.
So I am the one who's going to tell them that,
Absolutely.
these are the people. Okay.
You have the burden of proof to prove that you are the one of the top 10% in the country. They are not going to do anything. It's your case. You have to prove it from top to bottom. Okay.
Okay. And one last question. Is it a smart move to apply for NIW first and then build up my profile
no.
EB1A?
Well, NIW has its advantages, but it's an EB2 category. I don't know. Are you currently applying for a PERM-based green card or no?
So my EB2 is already going through my employer.
Then there is absolutely, I see almost zero advantage in doing an NIW at this point. You're already going to get a priority date through that filing. Why file an NIW? I would rather focus on the EB1.
But the EB2 regular would be like 2 years from now, and NIW could be a month or 2 from now. And then by the time I apply
hang on. NIW, hang on. NIW is EB2.
Correct.
Okay, so there's no difference in the dates.
I'm in a parallel path. From my employer side and then self-sponsoring.
Well, there is certainly no harm. I am just averse to wasting people's money. It's not really a waste of money. If it gives you peace of mind, by all means do it. No harm. There's no law that says you can't do an NIW before an EB1 or an EB1 before an NIW or an NIW before the PERM. None of this is relevant. You can file an NIW anytime you want. Okay, but here is my problem. One thing I just noticed. See, one of the things in NIW, what you're saying is that you can't really file a green card through PERM for this job. But what is a waiver? Waiver is a NIW waiver is a waiver of a job requirement, which is a part of PERM filing. So talk with your lawyers, figure that part out. I'm sure that can be figured out by comparing the jobs, NIW job and the PERM job. But that could be a potential hitch in this matter. Okay?
Got it.
Apply
Okay.
by all means.
Thank you.
Sure. Next question looks like New York. New York, go ahead, please. Area code 786.
Hi, Rajiv. This is a follow-up question. Hi, Rajiv. Can you hear me?
I can hear you. Yes, sir.
This is a follow-up question. This is a follow-up question to the H-1B layoff. So
Can I
want
can I
H-1B
ask
visa
you
for
can I
6 years.
ask can I ask you to
This
hold
is
just hello, one moment. I have to lock the conference. Give me 1 second.
Yeah, sure.
The conference is now locked.
Okay. So going back to your question, sorry about that. You were saying something about H1B. What was that?
Yeah, I'm on my 6th year of H-1B with an approved I-140. The priority date is in April 2017. So recently I got laid off and I have like about 60 days of grace period. So my question to you is like, what is the best option I have? I do not qualify for the dependent visa. So in my options, I was thinking to file D2 visa.
Yeah.
The other one is EAD in compelling circumstances. Or the third option, if there is a way I can expedite the request to I-485.
You can't expedite the filing of a 485. You've got to wait for the dates to be current. There is no shortcut to that. Compelling circumstances, EAD has its own advantages. Only problem is it's very uncertain. So B1, B2 is a lot more certain. You could think about first doing a B1, B2 application, then doing a compelling circumstances. Because if the compelling is denied, you still have B1, B2, you're in status.
Yeah, that makes sense. The only reason I was thinking about B1, B2 is since my intention is to work and settle, my green card is already pending. So
Yeah,
would there be a conflict or contradiction of filing B1, B2?
Look, typically we would not even be certain about B1, B2 because government has sometimes come back and said, well, B1, B2s are for recreational purposes. You're not really looking for a recreational purpose. But now what has happened is about a few weeks ago, USCIS itself said in writing that B1, B2 is a viable option in these circumstances. Okay.
Okay. So I can switch back to H1B, right? After once I get my B1, B2 approved.
Oh, yeah.
And if I get a new project, I can switch back.
Oh, absolutely. And if you get...
Thanks,
and
Rajiv.
yeah, one more thing. If you get a job while the B1, B2 is pending, you can get an H1B approval, then go get a visa stamp and come back. Go to Mexico and come back. Okay?
Okay, thanks, Rajiv.
Good luck. Okay, going back to next question is Sonu. H1B F1 green card considerations for an applicant with a child planning to attend school and college. Can H1B visa holders legally pursue PhD? Okay, let me just look at the questions. I'm on H1B working as a software application architect last 1 year. Son is 13, 7th grade. After 5 years, they'll start college. By the time he'll go to college, I don't have any chance to get my green card by that time. Okay. Question. When my son is planning to go to college for bachelor's, does he need to move to F1 or can he continue to be on H4? Yeah, until he turns 21, he can stay on H4. When I get my green card, will he be benefited? Only if under Child Status Protection Act, he's still a child. So CSPA basically just subtracts from your son's age the time the I-140 was pending and then filing the 485 if the dates are current. If the dates are not current, then he would not be able to benefit directly from your green card. Can I do part-time PhD in parallel on H1B? Sure you can. No problem. Yeah, but PhD doesn't mean that you are automatically going to get an EB1A. Absolutely not. It's not enough. Another question, can I take software classes teaching? No. That's a violation probably of your H1B. And the same goes for YouTube content. Okay. *5. If you have a follow-up question on this, press *5 on your phone. If you have a follow-up question on this. Okay, there being no question. Oh, here is one. 732, I think, is New Jersey, isn't it? Yeah. New Jersey, go ahead, please.
Hello, Rajiv.
Hello, sir.
So regarding the son, when he's starting undergrad from the age 18 to 22, 4 years, as you are saying, it will be only 21 years, he can enter that.
Mm-hmm.
So last year of the undergrad, so how he will be completing? Will he be continuing to H4, or we need to switch the last year to F1?
Yeah, so what you should do is time it properly. You should convert him to F1 so that he has at least 1 year that he is on full-time F1 status, so that way he can get OPT. Otherwise, he won't get OPT. Okay.
So what you are saying means while doing the admission and undergrad, we need to convert to F1? Or?
No, convert him to F1 in third year of college before he turns 21.
Okay.
Anything else?
Okay, I think.
Good luck.
I think I'm good. Thanks.
Good luck, sir. Next question is area code 567. I don't know, 567. Ohio. Okay, 1 second. Ohio, go ahead, please. I can hear you. Ohio.
Hello, Rajiv ji.
Hello, sir.
I have a follow-up question on the same. You pretty much gave me all the answer, but since every case is unique, I just wanted to go ahead and ask you this particular question. When I was with company A and I moved to company B, during that period I used about 20 days of unemployment. Now I have been laid off from company C. So am I allowed to use the remaining 40 days of that 60-day period?
No. Hold on, back up. I think you have full 60 days. Let's just look at this one more time. So last time when you transferred from employer X to employer Y, there was a 20-day gap, right?
Yes.
Okay. Now you want to go from Y to Z. The question is, do I have 40 days or 60 days? So the answer is you still have 60 days. Each time there's a transfer, 60 days come up again. But before we get there, when does your I-94 expire?
August 2023.
2023, right? May to June, June to July.
Yes.
Okay. And you are on H1B currently, right?
That's right.
Okay. So yeah, you have 60 days of grace period. And the 60 days begins on the date your pay period ends, not on the date you stop working.
Okay.
Okay. Anything else?
So, yes, in this case, if I am not able to find the employer within the 60 days period, when is the right time for me to file B2?
Yeah, maybe 50th, 55th day, somewhere there. Do it online.
Okay.
All right.
Okay.
Good luck.
Yes.
All right. Bye-bye.
Yes. Thank you so much.
You're welcome, sir. Bye-bye. Let's move on to the next question. Payroll and address change legal implications for green card holder with multiple employers. So you got your green card last year through your current employer in Chicago. You got a new job opportunity in Minneapolis, Minnesota. Both jobs are full-time and work-from-home jobs. You see, you Your green card approval. 1 second. Stupid Siri.
Is there something else I can help with?
Who called you, ma'am? Dumbass. Okay. So, going back to once a green card holder gets their green card, and after a month or 2 or 3, the circumstances become such that they have to take a second job or change jobs, I don't think that's a problem. So if you have 2 different pay stubs from 2 different full-time jobs, good for you. Why not? I don't see any problem with it. Are you breaking any AR11 rules? No. AR11 goes with where you live. So if I live in New York and I am working for a company remotely located in Washington, D.C., I don't have to file an AR11. When I move my residence to Washington, D.C., that's when I have to file AR11. Okay? *5. If you have a follow-up question, press *5. Okay, this one is from Kansas. Kansas, go ahead, please.
Hello, Rajiv. Thank you for taking this call.
Of course.
The question is, I have 2 jobs, but the payrolls are in 2 different cities and states.
That's fine. That's fine.
That's fine.
Yeah, you just have to check
But
with
when
your...
I go...
Hang on. Check with your chartered accountant, with your CPA, Certified Public Accountant. How do you manage the taxes? As far as immigration law is concerned, there is no problem. Tax law, just check with the CPA. Okay.
Not related to tax law, but further down the line, when I go for citizenship.
Yeah, I've already answered your question.
Sir,
Sir, I've already answered your question. This is perfectly legal. Nothing wrong with it.
So can I have 2 W-2s from 2 different...
Okay,
with 2 different addresses
I've answered this question. This is the 3rd time I'm answering the same question. Okay, so the answer is yes. Please don't ask me again. This is the last time I'm answering this question. Yes, you can have 2 W-2s from 2 different companies. I don't see anything wrong with that. Okay, go for it.
Okay, thank you very much.
You're welcome. Yep. Believe me when I tell you the first time. Let's go to the next question, which is downgrade from EB2 to EB3, potential layoff. So October 2022, 485 was filed, I-140 was filed under EB2. November 2022, I-140 was approved. December 2022, EAD received. Okay. Now you filed a downgrade. So the 180 days will begin from the date you filed the downgrade. That's February 2023. Okay. So that means that will be what? March, April, May, June, July, August. About August, that 180 days will be complete. What happens if there's a layoff? I don't think that's a problem because the law doesn't require you to have a job for 180 days. Just that your 485 remains pending for 180 days. So I think you're going to be fine unless you get an RFE next week that says provide a job offer letter or, proof of your employment. Then you have 70 some days to respond, almost 3 months actually, 87 days to respond. And if that brings you past the 180 days, you are still safe as far as I can see. Okay. So I don't see any problem here. Remember, for those 180 days, you don't have to have a job, much less the same job, as long as you don't get questioned. So as long as the 485 pendency, I-140 must be approved though. Did your I-140 get approved or no? Oh, one second. Let me make sure I covered this point. On Feb 2023, we filed a downgrade using I-485J. Why? Because did you have 2 I-140 approvals? Oh, this is very confusing. In order for you to downgrade, you have to have an I-140 approved under EB3 category. It doesn't look like you did. If you're on the call, press *5. I want to hear from you. Okay, let's see. Hi, is this your question?
Yes, sir. Can you hear me?
Yeah, is this your question, sir?
Hello?
Yeah, I can hear you fine.
Yes, sir.
Okay.
Question number 10.
Okay, so
Question number
my
10.
question, yeah, I got it. My question is, when you asked for a downgrade, did you file a new I-140?
Yes, sir. We filed new I-140 in EB3.
Okay. Has that been approved or not?
Yes, it's approved, sir.
Very good. So that means you have to wait 180 days from the date you asked for the downgrade.
Okay.
And you don't have to have a job.
So,
You just have to have the 485 continue to stay pending. That's all.
got it.
Okay.
Got
So
it.
I think you're safe.
If I have a question if you are done.
Sure. Go ahead, please.
So, one suggestion I got was like in case of layoff, before 180 days happen from supplement J, one suggestion was that I should submit a withdrawal of supplement J and tell USCIS that, I lost my job, so I want to move my application back to EB2.
Oh, I would definitely not say I lost
because-
my job. I would definitely not say that. You can withdraw the supplement J
Okay.
without giving a reason. And does that put you back in a safe category? Yeah, it should, because that way, before your request for downgrade is acted upon, you've asked for a withdrawal. So that could work, but I think if you are able to reach the 180-day period, 485 pending on EB3, you are going to be safe even then. So I don't have a particular preference. Both are options.
Got it.
Good luck.
So, like if in other scenario, if
Mm-hmm.
the employer is not very happy and they decided to withdraw the application of
Then you should
I-140 EB3.
yeah, you should immediately withdraw your supplement J. Actually,
Okay, got it.
yeah. So you need to withdraw your request for downgrade. Actually, that's what you'll withdraw. Okay.
So when I which I-140 will prevail? Like if supplement J is withdrawn.
You have to request that.
If I find a new
Yeah,
employer,
it should, because see, the only time your EB2 I-140 would get disturbed is if they acted upon your request for downgrade. If they don't act upon your request, then obviously the old one is undisturbed, right?
Yes.
So that's just logic. Okay. Let me move on. Good luck to you.
Thank you, sir.
You're welcome. Okay, this one is area code 973, which is New Jersey. New Jersey, go ahead, please.
Hi, Rajiv. Thank you so much for accepting this.
Mm-hmm.
I think you might have answered everything, but I joined a bit late, so I missed the mark.
I'm not going to repeat my answer.
response of yours.
I'm not going to repeat my
That's
answer.
okay.
Yeah.
I'll go back and look.
Yeah, listen to the recording, okay?
Yeah, I'll go back and look at your recording.
Yeah.
Yeah. But one quick question,
Uh-huh.
Rajiv. So basically, right now, I have EAD and AP.
Okay.
And 180 days has been passed since I applied for my 485. So that's
Good.
a quick thing I want to say to you. But my question is, I am planning to change an employer.
Okay.
But my past employer who did my 485 is like not giving my I-140 approval notice.
Okay.
So would that impact me in any way in change of employer?
Why would hang on, your 485 is pending, right?
Yes.
You would have a copy of the I-140. Otherwise, you couldn't file the I-485, right?
I don't have it.
Your lawyer should have it.
But all the documents have been given to the... Yeah, my lawyers are having it, but they are not giving it to me because they need an approval from the employer.
Hang on. Look, in most states, it is unethical for a lawyer who represents both sides to withhold any document from any client. Okay, so like in Virginia, the rule is if I have two clients, I put it in writing that look, we represent both sides. You can't, the whole file belongs to the both of you. So if you want a complete copy of your file, I don't have to seek permission of the employer. I have to give it to you. That's your property, even though some of the documents are the employer's documents. In the same way, if the employer calls and says, I want a complete copy of the file, including the employee's documents, I have to provide it. Okay. So you call the New Jersey bar and find out what the rule is. Because if the lawyers don't give it to you, you can tell them I'm complaining to the bar. You're holding on to my documents. That's illegal. Okay, that's number one. Number two, you can file a Freedom of Information Act request and get a copy of your own paperwork. You should get a copy of the approval notice with that. Okay.
What was that you mentioned? Freedom of?
FOIA, Freedom of Information Act request. So just type FOIA, USCIS. You can do it online, doesn't cost anything, zero money. Okay.
All right.
Good luck.
Thank you so much.
You're welcome. Okay, and the next one is also New Jersey. I am popular in New Jersey today. Area code 732. Go ahead, please.
Hey, Rajiv, a quick question on this interfiling thing. Can I consider my son's age locked by virtue of interfiling?
No.
140 was approved.
Hang on. So let's say you got the old I-140 under which your son's age, your 485 was filed, son's age is locked now. Okay. When you, this is what I understand. When you file for a downgrade, your son has to be under 21 on the date you file for the downgrade. Otherwise, he doesn't meet the CSPA requirements. In other words, your son's age goes with the I-140 that you get your green card through. Okay.
Right. So I downgraded in EB3 and then again upgraded in EB2, and that EB2 date was I-140 was approved. EB2 date was final action date was current when I interfiled. So I can safely assume that my son is age is locked.
Well, they actually now they don't even look at final action dates. They look at dates for filing. So I don't know the facts. I don't know the facts of your case. I would hate to make a guess like that. But the bottom line is, if the I-140 that you are going with locks in your son's age, then you are safe whether you go with the first or the second I-140.
No, this is just for the specific of interfiling. That's why my question is, because I interfiled with my, so that will interfile will lock CSP, right?
Well, again, you're asking me the same question in a different way, and my answer is still the same. Whichever I-140 you go with, there are two I-140s. Whichever one you go with, if it protects your son's age, then you are good. If it does not, then you are not good. So you got to sit with your lawyer and do the math.
Okay.
Good luck.
Okay.
All right.
Thank you.
Bye-bye. Yeah, that's one risk with interfiling as well as downgrades. Okay, which one was this? Did I do this? Downgrade from potential. Oh yeah, we just did this. Arushi, we answered that question, was a frequently asked question. Question number 12. Yeah, you have a J1 and an approved I-140. Yeah, I think they could stop you entering. Because J1 is a non-immigrant visa. It does not allow you to have an immigrant intent. You know, it's interesting. I used to think the same thing about TN visas too, but there's actually a case on the books that says just because I-140 is pending doesn't mean you can automatically deny entry. So I'll have to look into it whether that kind of case also exists on the J1 side. This case that I'm talking about existed on the TN side. So some of the principles are similar. I can't answer your question without reviewing the law, but there might be some kind of a relaxation here for J1 having an I-140 approved. but I certainly don't know it off the top of my head. Sorry. Okay. Next question. Immigration intent F1 visa renewal. Spouse is approved I-140. You're studying PhD, more than 4 years. Want to go get your visa soon. Wife is on H1B with I-140 approved. So, her I-140 doesn't mention your name because you got married afterwards. So there's no immigrant intent. It can't be extended to you. How much of a risk is it to get a visa stamping? Always a risk. Never know. But you can always come back on H4. So that's not a risk. Okay. Star 5. If you have a follow-up question on this, press star 5. Okay. So we are done with all these questions. Anybody who has any question, press star 5, please. Anybody who has any question. Let's see how many we got today. 7 so far. 8. Okay. 8 questions it is. I'm going to go in the order that, 11. Okay. No worries. 11 questions, 11 people with raised hands. All right. No, 12. One more. Okay. I'm going to go in the order that you guys logged in. Okay. So first let's go to California, which is 408. Okay, 408, go ahead, please.
Hello. So I have one follow-up question on the previous F1 question, and I have a new question as well.
All right.
Which I was not able to post on the forum.
Okay.
So for the follow-up question, I was not able to give the context behind my question. So last week of April, the candidate was given a notice that from today you have to stop working, and for next 2 months you will be on payroll. And the candidate is on F1 OPT.
Okay.
Now, his OPT EAD expires in August. So, his timeline to apply for STEM extension starts in end of May, like the end of this month. So, in this case, is it advisable to apply for STEM OPT just as soon as the candidate hits the 90-day mark and get the STEM OPT EAD so that in case after the 60 days of being on payroll, the candidate would still have 60 days of OPT and 90 days of STEM OPT, or the other way around, total 150 days.
Okay, I am so lost with all this. I am so lost with all this numbers. I have no idea what you're talking about. All I can tell you is, listen to this carefully. You cannot apply for a STEM OPT if you've been fired by that employer. You should not. That's wrong.
Even if the candidate is still on payroll?
Well, they've been fired, right? A STEM OPT offer says that we've got him for the next 2 years. Okay? Yeah, once you file, hang on, let me finish. Once you file, and then the person gets laid off, that's different. But if you're already laid off and you're filing, I think there's something wrong with that. Personally, I wouldn't advise it. Okay? So I'm not going to go into the days and the dates. Don't do that again. I don't have enough time. Hang on. I've got 12 people waiting. I don't have time to go into all that. You can always make a consultation appointment with us. But going by what I just told you, apply it to your facts. Do not file for STEM OPT extension if you've been fired. Okay. Next question.
Okay. Got it.
Yeah.
For the next question, I wanted to ask if I would need to book a consultation for this scenario that I am owning a company, an IT services company, and I am getting projects that are outsourced by other companies.
Okay.
Now, I am wanting to hire a contractor from a consulting firm who would be on H1B. So, is there any intricacies or nitty-gritties that I would need to take care of to be dealing with USCIS and the immigration stuff, or it does not affect my company? I'm just getting a contractor.
Is your worry about this person's status, or is this are you a green card holder or a U.S. citizen? What is your status?
Yes, I am a green card holder.
So then you have nothing to worry about your status. So what are you worried about? You can always hire contractors. Nothing wrong with that.
So in both terms, one is USCIS sending an investigation onto the company I established.
They can.
And in terms of the status for the contractor that I have.
Well, that's a complicated issue. Yeah, for that you will need to get an appointment. Spend a half hour with me. I have to review many things before I can answer that question. Okay.
All right. Yeah. Sure.
Yeah, that's complicated. That's not something I can answer. Okay.
Sounds good.
Good luck, sir. Good luck. Okay. I'm going to Arkansas, area code 479. Arkansas, go ahead, please.
Hey, good afternoon.
Good afternoon.
So, my friend got picked his H-1B from the current genuine US company, and he has also filed H-1B petitions with the consultancies as it was his third attempt. He's on F1 visa currently. So before that, for the last 2 years, he has filed H-1B from the current company, like US-based company. But I guess seeing the market, he got in the rat race of leveraging consultancies for increasing chances. Now USCIS is becoming stringent for making most of the consultancies as fraud cases and will be giving NOIR or revocation notices in the next H-1B extension. I'm sorry for the long story, but I'm worried for my friend. Like, even though his lottery got picked from the genuine US-based current company, will he be given 221G or NOIR in the future for he filed other petitions as well?
I can't predict. I can't predict. There's no way for me to tell you which way it's going to play out. Even the government doesn't know what they're going to do. They are trying to make criminal referrals and investigations. I'm sorry, there's no answer to that question.
Okay. Can I ask one more question if it is okay?
If you make it really quick, yes, you can.
Yeah. Okay, yeah. And if suppose the scenario is like he did not get picked at all, and he for the next year he just used his current company, only the genuine company for the H-1B filing. So is it something like that? His records will still be with the USCIS for this year?
What you're asking me is this: will they catch him if he continues with the only one company? I don't know the answer to that question. Have they already caught him? Sure. It's very easy to find out when somebody has done multiple entries. That's a given. Is he already on the list? Probably. Will they let him go just because he didn't file? I don't know the answer to that question. It depends upon the amount of his culpability. So let me not get into that. That's a long discussion. Bottom line is, we don't know what's going to happen. What should he do next? He has to make a choice. Does he want to file an H-1B or not? Okay, and if he does want to file an H-1B, what's going to happen? Nobody knows. So with insufficient data, he's got to make a decision. Ma'am, I've got to go on to my next call, okay? Good luck.
Oh, yeah. Thank you. Thank you for
You're welcome. Area code 413, Massachusetts. Go ahead, Massachusetts.
Hey, hi Rajiv, this is Shumavo. So one question on H4 visa. So can I basically book an H4 visa date before marriage, but my interview will be post the marriage? So is that fine? Like if I book a slot, considering that there is a slot?
Absolutely no idea. So what should you do? Go check the frequently asked questions on the consulate and the contractor's website. And if you're not able to find the information, just go ahead and send an email to the consulate. See if they respond. Okay.
Okay. So it's like, I mean, logically, obviously, after marriage, you are supposed
I'm not going to engage in something I have no idea about. No idea.
Okay, cool.
Sorry.
No problem. And one just informative question. The last one, I will make it quick. So I have my visa valid from a different company, which is till 2024, but my I-1, as in my I-797 is valid for my current company till 2025. So even if my visa expires in 2024, but my status will be valid because my I-797 is valid, right?
It's not the I-797, it's the most recent I-94 that matters.
Okay. Okay, cool.
Good luck.
Okay, cool.
All right. Let's see who's next. This is Illinois, I think. 1 second. Oh, this stupid Siri. 1 second. Let's go back to... I was going to Illinois, which is area code 815. Okay, Illinois 815. Go ahead, please.
Yeah, hi Rajiv. Can
Hello.
you hear me? Yeah, so my question was, does maternity leave on STEM OPT affect the status of the visa holder?
I have no idea about this. Why? Because this issue only has come up to us in H-1B context where it's okay. It doesn't cause a violation of status. So you'll have to check with your DSO. And in fact, if you find out, please let me know as well. What do they say? Because a maternity leave in the context of H-1B is absolutely no problem. H-1, if they have to go on maternity leave, they still maintain status. Okay. But
And what about H4? H4?
see, H4 तो वैसे ही काम नहीं करता. So what is the problem?
No, if she is working on H4.
Then there is no issue. I mean, if she's working, because H4 EAD, you have the option but not the obligation to work, right? So it's no problem. She can be on maternity leave on H4.
Okay.
Okay.
Okay, and can I ask one more question?
Yeah, go ahead.
Okay, so if somebody is on day one CPT or STEM OPT, can the employer still file for I-140 for them? And what if that I-140 is approved or filed and then I change the employer to employer B?
Okay. First of all, Google my name, Rajiv S. Khanna, Economic Times. I have an article about this. Can you file for a green card while you are still on F1 visa? Read that article. Okay. Now, once you get your I-140 approved, your priority date becomes your property. If you go on to another employer, you have to start the green card again, but the priority date will be the old one. This is true even if the old employer revokes the I-140. Okay?
Okay. Okay.
Good luck.
And then obviously if it is still pending and not yet approved, then also the new employer has to file again.
Yes, absolutely.
Okay. Okay.
All right.
Okay. Thank you so much.
You're welcome, sir. Good luck. Okay, let's go to New York, area code 917. Go ahead, please.
Hi, Rajiv ji. So this is one of the previous questions about the EV2 NIW that you answered in the citation question. So I think the biggest two advantages that I'm looking for is first, if I job hop for forever, I don't have to go through 2.5 years of the PERM process ever again.
Hang on.
And second,
the PERM process is typically 1.5 year most.
Yeah, but right now I'm struggling to get it because the LCA or the PWD only took 9 months, and then I'm struggling to get through
definitely.
the recruitment process.
Hey, look, you won't find any argument from me for having multiple options. I'm always for it. But if you asked me and you came to me and asked me as a lawyer, do you want to handle our national interest waiver? I'll definitely lay it out for you. Are you sure you want to spend X number of dollars just to have this peace of mind? And the answer is yes, I would. Absolutely. Would I do it? Yeah, I would. I would file an NIW for myself.
Yeah, that is what I was. And then my spouse gets H4 right away, right? As soon as it gets approved, right?
Yes.
The NIW
yes.
gets approved because
yes. Yeah. Yes, that is correct.
And then should I tell my employer then stop my EB2?
No, chalne do. Well, you see, that's the only problem. There's a conflict because one of the things you are arguing is that don't make me file for PERM So that's a complicated question. Make an appointment with me or talk to your own lawyers how to deal with that problem. It can be dealt with, but I've got to know a lot more. I've got to see your ETA 9089. I've got to see what you filed. Okay.
Okay, got it.
Good luck. Let's see. Next one is 901, Tennessee. Tennessee, go ahead, please. 901. Let me grab some water.
Yeah. Hi, sir. So last year, I was in my new company. I got an H-1B.
Okay.
So I went for stamping. I got stamped. And then what happened was like the new company at that time, they were not ready to give the job. So I haven't traveled. So meanwhile, my current company went for L1B.
Acha.
So at the time I contacted you.
Okay.
So can I go for stamping? You said you can go for stamping. I went stamping.
Yes.
They canceled my H1B and then they approved my L1B. So I came here in US.
Hang on.
Now,
Did you say?
like,
hang on.
can I
Hang on. Back up. Did you say they cancelled your? Did they revoke your H1B?
No. In the visa stamping, they write CWOP.
They write what?
CWOP, cancelled without.
Oh, cancelled without prejudice. Okay. Okay, got it. You had me going. It's okay. So none of that really matters because you went past October 1st of that year. So that means you're already out of the quota.
Right.
You're out of the quota. You can apply for an H1B without any problem.
Okay, so but can I transfer that? I mean, is it that visa is still valid? Can I transfer the visa to my current company?
See, you don't transfer visa. You transfer H1s. That visa is already cancelled.
Yeah.
But your H1B lottery exemption is not cancelled. Your company should be able to apply for an H1B for you. And there is definitely an advantage on being on H1B rather than L1B. Okay. So go for it. You can do an H1B. You can apply for it today if you want. All right.
Okay, thank you.
You're welcome. Let's see. Next one. We just did Tennessee. I think we need to go to Texas, which is 832. Texas, where are you? 832. What? I don't see you anywhere. Oh yeah, here you are. Okay. Go ahead, Texas. Oh, what did I do? I screwed that up. But 1 second, please. 1 second. I gotta get you back. No. I thought I was trying to get 832. Hang on, there are two Texas here. That's what is causing the problem. 832. Let's get that back. 832. Okay, I can't hear you yet.
Thank you very much, sir.
Yeah, 1 second. This is area code. Where are you calling from? Is this area code 480? Who's talking?
No, it's 832.
Okay, good. I got you. Go ahead, please. Go ahead, sir.
Thank you very much, sir, for doing this. We, as a community, truly appreciate that.
Absolutely.
I have a question that I'm wondering what would be the effect of obtaining a new TN visa in case your EB1 application is not approved?
Okay, so I remember I just talked about TN a moment ago. I said even if your I-140 is approved, there is a case that says just because I-140 is approved doesn't mean you automatically say no to a TN. Okay, so in your case that's not even approved. So I don't know. I think you should be okay, but who knows? I mean, technically they can say you have immigrant intent, we are denying you TN. But it's hard for me to predict. There is no clear answer to this question. If you had asked me a few months ago, I would have said clearly, yeah, I think you're going to have a problem. But ever since I saw that case, I'm not so sure anymore. So, hey, who knows? Might work out.
Okay.
Good luck.
Okay. Thank you, sir.
You're welcome. Okay, let me go to, this is the next one is also Texas. Okay, that's what is causing the problem. 469. 469. Why is it not unmuted? Okay, now it is. 469, I can hear you. 469. Hello.
Hi, Rajiv.
Hello, sir.
Can you hear me?
I can hear you now.
Yes, sir. So I had a question regarding my PERM and I-140 filing.
Mm-hmm.
So this week, I got to know that I was laid off,
Okay.
and my PERM is processing since August 2022.
Mm-hmm.
So I'm expecting it to get approved sometime in a month or so, since right now they are currently processing July 22 PERM applications.
Mm-hmm.
And then after that, I've already paid for a premium processing of my I-140.
Okay.
My question is that working on the severance period for the next 2 months with my current employer,
Mm-hmm.
can the PERM be still processed? And then once the PERM is kind of approved, can the lawyer still file for my I-140 and get that approved as well?
Yeah, I think they can. There are two things that are important. Number one, does the employer have the intention to hire you back? This is complicated. I can't do it in a 2-minute call, but I'll give you the bottom line. The bottom line is, as long as the employer did not eliminate the job, just eliminate you for now, and they intend to hire you back when they have the position open again, this is difficult to describe, but it is certainly possible for them to continue with the I-140 if they have the intention to hire you back. Like I said, more complicated than the way I said it. Talk to your lawyers. What do they recommend? If they feel comfortable filing it, there's no harm. It's not your filing, it's your employer's filing. Okay?
Okay, got it. Thank you.
Good luck. Ohio, area code 513. Go ahead, please. Ohio.
Yeah, hi, sir.
Hello, sir.
So I'm not sure. I asked a question on the forum, so I'm not sure whether it was taken up or not.
Already taken up.
my
Anything that was already that's been posted, it's been taken up. Wait for the recording. Okay.
Okay.
Good luck.
Okay, sure. Thank you, sir. No
You're
problem.
welcome. Bye bye. Okay, this number is showing anonymous blocked. So I don't know. You might be over on a voice over IP. I don't know what's. So whoever you are, anonymous. Go ahead.
It's the follow-up question regarding the 10th question, question number 10.
10.
So,
1
in
second.
case of layoff-
Let me get there. 1 second. 10. Downgrade from EB2 to EB3 and potential layoff. Yeah, I remember. Go ahead.
So, in case of a layoff, right? So, am I safe to completely use my EB2 EAD, which is above 180 days, and join company B, and company B file for 45J, and then on my own I withdraw by 50J?
Yeah, absolutely. Why not? Do discuss it with the lawyers of the company, because I don't know how they would want to do it, the future company. But yeah, I think nothing wrong with that. Okay.
And in a good scenario, if I get a good job offer before 180 days, since supplement J, right,
don't submit.
can I change
Hey! Don't submit supplement J before 180 days.
Oh, with the new employer.
Yes, don't do that. You can start working on an EAD, but don't submit supplement J. That's why I said talk to your lawyers before you do anything. I can only give you very broad advice. But it is possible to join another employer within the 180 days without jeopardizing your AC-21 protection. But it would be a bad idea to file a supplement J before 180 days. There's no deadline on supplement J. You can file it today, you can file it 3 months from now. Nobody stops you.
Sorry, sir, one more question. Same question, I got a little confused, if you give me permission.
I'm going to give you maybe 20 more seconds. Make it quick.
Yes. So in case of layoff, right? So if I join the company B, so at company B also, should I wait to file supplement J after 180 days?
Yes, yes. So what you do is you join the company using your EAD, but hold off on the supplement J until 180 days are over.
Okay, got it.
Got
Just
it?
withdraw it.
Yes, yes, absolutely. Okay.
Thank you, sir.
Good luck. Okay, let's go to area code 480. That's Arizona. Arizona, go ahead, please.
Yeah, hello, sir. I'm Akash. I'm currently on F1 OPT, and I just started my job.
I can't hear you,
got the
sir.
offer
Sir,
from
I can't hear you at all. Can you get a little closer to the mic?
You cannot.
Yeah,
Yes, sure.
and talk slowly, please. Mm-hmm.
Okay. Hello, sir. I am Akash. I'm currently on F1.
Mm-hmm.
And I joined the job in a startup in
Okay.
Seattle.
Okay.
And currently, I've gotten another offer from a company in Chicago.
Okay.
And both are legit companies, no consultancy business. But my H1B got picked from the other company.
Okay.
And I'm about to join the other company in Chicago.
Okay.
And I could not join earlier because we had an SPP issue. Like we had an issue with SPP Bank.
Okay.
And they did not know whether the money was getting stuck and
Okay.
holding my
Okay.
offer.
Okay.
But after this, it got unstuck and like they got the money back. So they told me that the offer is valid. So
Okay.
I'll be joining in May. So then I can file for my H1B petition.
Yeah, why not? You have not filed, hang on, you've not filed multiple H1B lotteries, have you? Or did you do it through the current employer and the future employer?
I had my current employer and that also because I did not.
And hang on, slow down. Just answer the question that I asked and then stop. Okay, so are these two companies related in any way to each other?
No. One is in quantum, one is in computer science.
Okay. Are there any common directors, stockholders, officers in the two companies?
Nothing. No, completely different.
I think you should go for it. I don't see any problem.
And I have the mails and everything.
Yeah.
I gave the interview.
Absolutely.
And
Hey, this is given by regulations. You can do multiple filings. You just can't do it collusively. So I wouldn't worry about it. Go for it.
Yeah, okay.
Okay.
That is completely fine for me. And the other question I had, like they told they'll file for green card also. So so I feel that I am currently on F1, so it's single intent. It's not dual intent, so I cannot file for green card. Also.
Well, like I said, hang on. You must have heard me earlier. Just Google my name, Rajiv.
I did go through yours.
Yeah.
I did go through yours.
So read that. I have already laid out the principles. Rest you should discuss with your lawyers. Okay.
Yes. So my question was not that. My question was, can the lawyers start LCA for the H1B without my name actually being on it? And once I get my H1B, then I can file for the easy one because LCA is approved. So that was my question.
LCA? I don't think LCA has a name. I don't remember it, but I don't think LCA has a name on it.
So I can ask my company to file the H1B LCA for firm. Meanwhile, it takes
Okay. Hang on. Sir, there's a lot of confusion in what you're saying. So I'm going to, this is my last comment on this. My last comment is simply this. There is a difference between LCA and PERM. LCA is something you file for an H1B. Can your company start your PERM? Let me finish. Can your company start your PERM process without you even joining them? Absolutely. Okay.
Okay.
Good luck.
That answers my question.
Yes.
It was not for LCA, but for PERM.
No problem. Good luck. Okay, Georgia, area code 404. Go ahead, please.
Hello, sir. I have this question. If USCIS adds any fine in its approved petition, can a lawyer represent the applicant in front of USCIS if there is no open case with them?
Okay, that question is not complete in information. So, tell me which petition are we talking about, first of all? Oh, you are the person. Oh, I recognize your name. Hang on. I recognize your name. You have been communicating with me on LinkedIn. And you keep asking me the same questions over and over again. Here is the bottom line. Any lawyer can represent you personally if you have a problem. But can they represent somebody else who filed the case? Absolutely not. That's a totally different situation altogether. But you see, if there isn't any allegation or any blemish against you, obviously you need representation, right? So the lawyers can represent you. Okay.
Yes, but there is no open case with the USCIS because they have added a finding on approved petitions. Is that all right?
So that's exactly what you would have to do. You would have to say, hey, you made a finding against me without me being even a party to the case. How can you do that? So yes, that kind of case should be litigated, and that kind of case is litigatable because, I don't know if that's a word, it is possible to file a litigation because you are being harmed by it. So if you were a total stranger party to it, you had no harm coming to you, you would have no standing to sue. I think here you would have standing. Okay?
Oh.
Good luck, ma'am.
Thank you, sir.
You're welcome. Florida, last question of the day. Go ahead, please. Florida.
Hi, Rajiv. Just a follow-up question on the B2 visa, H1B grace period. So you recommended B2 visa would be the best option, right?
No, I didn't say best option. No, hang on. I didn't say it's the best option. I said it's an option. It's different for different people.
EAD compelling circumstances.
Yeah, it's different.
Sorry about that. So
it's hang on. The question that was asked of me was that member of our community wanted to know if they should file within the 60-day grace period a B1, B2, or should they file a compelling circumstances EAD. I said for you, B1, B2 first and then compelling circumstances makes sense, because if compelling circumstances is denied, you still have B1, B2 going. So you won't be out of status. That's a different case. Now what's your question?
Yes, so when filling out I-539, right, how do I convince officer that I will leave the country?
Okay.
And
you don't do
planning to redo my H1B.
You don't do any of that. Just go to my blog and read the second entry. Okay? It explains to you how you should file the case.
Okay, you have
on my blog on immigration.com.
Okay, and one last question. Okay, sure, I'll do that. And one last question on that. So let's say if I find a new project within 50 days before my grace period, can I still remain in the country and do the H1B and start working?
Oh, yes.
Or I still have to go out?
No. What happens is, as long as your second H1B, the transfer, is received by the USCIS before 60 days are over, you can stay in the country on H1B and you can actually start working. If you are still within the grace period and USCIS has received your transfer, you can start working. Not only can you stay in the country.
If I'm on 61st day,
and then you are
like if I'm out of 60 days,
then you can't work and you can't stay unless you filed a B1, B2, and you can't work. You can only stay.
Oh, so I cannot work after 70 days. Even on H1B receipt, after I have to get a visa.
No. If you filed,
I have to go out of the country and then work.
No. If you filed your H1B, transfer within 60 days, then you can work, no problem. But if you filed it on the 61st day, you can neither work nor stay. If on the other hand, within 60 days you filed for B1, B2, then let's say 70th day you filed an H1B, you'll probably have to go outside USA for visa stamping. Okay, I've explained all of that.
I cannot work until the visa is approved.
You cannot. Exactly.
Makes sense. Yeah.
Yep. Okay. Good luck, sir. You're welcome. Okay, guys, the very best of you. Best of luck to all of you. It's always good to hang out with you. I'll see you again next Thursday at LinkedIn. Okay, take care, everyone. Bye-bye.